My name is Matt Parmentier, and I'm an associate attorney at Edgerton, St. Peter, Pettick, and Rosenfeld in Fond du Lac. Yeah, most of my work involves municipalities, and most of the municipalities are towns. Municipalities have to understand when they're dealing with a nuisance ordinance case that it's not your typical lawsuit, and it generally doesn't involve your typical parties. The defendants in these types of lawsuits are not sophisticated developers. They usually don't have attorneys, and things tend to go a lot less smoothly than they would had they been a sophisticated developer or a person with an attorney. And there are a lot of things that the municipality needs to be aware of before getting involved in one of these cases. There are both public and private nuisances, and then there are nuisance ordinance violations, and my talk was on nuisance ordinance violations. But sometimes what municipalities see is that along with nuisance ordinance violation, there may be a structure on the property that's in such bad shape that a raise order needs to be issued for the property too. So at the same time that municipalities are participating in these nuisance ordinance enforcement actions, they should watch out for other issues that may require a raise order for the property. Two that I touched on in my talk today were to take a lot of pictures. It's probably pretty obvious, but pictures are really good evidence in these cases. It's easier to show the judge by attaching it to the complaint or other documents. Show the judge what the property really looks like is a lot more effective than trying to explain it in words by quoting some draconian language from your nuisance ordinance. And another thing that is good for attorneys to understand is that they need to be very specific in what they ask for in these cases. So a common mistake, or a mistake that I've seen made, is to request relief consisting of something really generic, like the defendant must remove all of the nuisance items from the property, because that just generates a new dispute over what the nuisance items are. So we suggest that attorneys be very specific when requesting relief or drafting judgments, and say either what has to go, or even better, identify those items that can stay and draft a judgment or ask for a judgment that requires everything else removed. It avoids that ambiguity and future disputes about what the judgment really means. The first is to always conduct site inspections. Municipalities probably frequently do this, all of ours do, and it doesn't have to be anything fancy. It just involves the municipality or some staff member going and looking at the property and documenting its conditions, so that the municipal governing body can decide whether the case is ready to be settled or not. The second thing that they need to be aware of is that settlement discussions in nuisance cases often simply involve the cleanup of the property, and that can drag on for a really long time because the defendants tend to clean up only as much as they think they need to, or less. So frequently a municipality will be faced with a decision of whether the property is good enough, and that's a tough decision to make, but there are ways to settle a case and draft a settlement agreement that protect against that by including financial provisions that encourage additional cleanup or discourage the defendant from allowing the property to fall into worse conditions. The first piece of advice for enforcing a nuisance judgment is to ask for all of the appropriate relief that you need up front when you're filing your complaint and when you're talking to the court. So you'll want whatever financial penalties you may have under your ordinance. You'll want probably an injunction. You'll want an abatement order. You'll likely want permission for the municipality to go onto the property and remove the nuisance if the defendant doesn't do so him or herself. And we also use what's called a warrant to abate nuisance, which is an order for an officer to actually enter the property and remove the nuisance. And that's a good tool for many of our town clients because it involves someone other than the town doing the abatement, which can save time and money for the town, and it also avoids the risk to the town of entering the property and doing something wrong and exposing itself to liability.